Welcome to Upticks with Jake Falcon, founder and CEO of Falcon Wealth Advisors. In this podcast, we help high net worth individuals overcome financial complexities. We do this by enhancing financial literacy and discussing topics in a language free from industry jargon. Join us as we help explain exactly what having a solid financial plan means, as Jake draws from years of experience in helping hundreds of individuals get financially organized and focused on their goals. We hope you find Upticks educational, entertaining, and shareable. Now, on to the show.
Welcome back to the show. This is episode 209, Wills and Trusts with Emily Sullivan. Emily, thank you for joining me on the show.
Absolutely. Happy to be here this morning.
Yeah, and Emily is with Heritage Law right here in Kansas City and new to our audience. So before we dive into the wonderful world of wills and trust, Emily, I wanted to share some of your background. So do you mind sharing with our audience kind of where you grew up, went to school, and how you got into law?
Yeah, absolutely. So I grew up in Wisconsin, small town, ended up moving over to the eastern side of the state near Milwaukee. That's where I graduated from high school. Go Tosa East. I went out to Boston, to Tufts University, to do my undergrad. I had a degree in psychology and economics. I also swam on the swim team. Mascot's the Jumbos, so proud to be a jumbo swimmer, maybe not the dream of every 18-year-old. And then I came back to Wisconsin to do my law degree. I worked in New York City immediately after law school, moved to Wisconsin and worked at a firm there, and then moved to Kansas City about 15 years ago. And for the first 15-ish years of my practice, I did litigation. So I primarily represented large companies around the country. The travel started to get a little long. So about 5 years ago, I decided to kind of 2.0 my career, jumped into estate planning, and now I'm really enjoying having a local practice.
Yeah, that's awesome. And what brought you from Wisconsin to Kansas City? That's a little random, isn't it, or no?
It is a little random. I don't have family here. It was my husband's job. So we relocated because of that. And then you have kids, and then you have roots. So here we are.
Got it. So are you a Packers fan or a Chiefs fan?
Oh, if they're playing each other, I'll always root for the Packers.
Yeah, I don't blame you.
He's in the room. He's 12, and I don't really want to break spirits. So
awesome.
We're on the same team when we need to be.
Fair enough. Well, that's a cool football. I mean, that's a historic football organization to root for. So I don't blame you. I don't blame you there. And is it true? Like my buddy is like a shareholder. Can't you buy like 1/1000? Are you too?
Yeah, me too. Yeah. It's kind of like, you have a kid and they get a piece of stock in the Packers. So you can't get season tickets until you're forever old, because you have to be on the long waiting list, but you can take an ownership interest.
Ah, that's interesting. Maybe at the end of the show, we could talk about if that interest is transferable via a will or a trust.
True. I like it.
Now, obviously being in, Kansas and Missouri here, I'm assuming that you're licensed to practice with clients both in Kansas and Missouri. Is it just Kansas and Missouri, or is it all over the country? How's that
So
work?
you do have to be admitted into each state where you're drafting documents. For me, that means Kansas and Missouri. I've also taken the Florida bar exam, the New York bar exam, California, and then I was admitted in Wisconsin. My law partner is admitted in Colorado as well. So we're able to handle a fair number of states. I will say that when it comes to drafting the documents, and because of the different state income tax and estate taxes that may apply, we do primarily like to do Kansas and Missouri. But when it comes to kind of one-off documents or powers of attorney, things more ancillary, we will be able to do it in those other states as well.
Okay, thank you. Yeah, that's great to hear. We have clients in 30 states, so that's why I asked. We've got to get more and more clients across the country, and so that's good to know. So let's dive into it here. So probably one of the most common questions that I get, typically when I meet with a new client, I ask them, do you have a will or a trust? And sometimes they look at me and say, yes. And it's almost a trick question, because I was like, do you have a will or a trust or both? And so do you mind just kind of in plain English here a little bit, explaining the difference between a will and a trust for our audience that may not understand the difference?
Sure. And this is something that trips a lot of people up. A will is basically a document that gets filed in probate after you pass, and it's considered your voice for the probate process. So a will doesn't avoid probate. Probably half of your clients have had some type of experience with probate, and those that have know that they should try to avoid it. Those that haven't, it doesn't mean anything until they kind of encounter it. But a will doesn't avoid probate. So it's just kind of what you want to say will happen to your assets after you pass. A trust does avoid probate. And so it's more of a narrative document, if you will. It has a lot more built-in clauses, if not A, then B, if not B, then C. And so it's more comprehensive in that regard. But the biggest takeaway is wills on their own don't avoid probate, trusts do. There are ways to develop an estate plan with a will that can avoid probate, and that's largely done by naming beneficiaries directly on your assets, and that's appropriate for some clients and not others. But so there are kind of two paths that most estate plans can take, depending on whether you're a will candidate or not, or whether you're a trust candidate because of some other types of issues that push people into the trust camp than a will camp.
Got it. Yeah, thank you. And I've had several clients that have gone through the probate process, and it typically isn't an enjoyable experience. It's lengthy. They have to pay an attorney, right? Legal fees
Exactly.
to help get all that done. So in your experience, is it, and maybe there is, but so I'm curious, so who does it make sense to not have a trust, but to have a will? Like when would that apply?
Sure. So I find it's useful when you're dealing with older clients who have adult beneficiaries who they feel comfortable inheriting a lump sum of money. So, if we're dealing with minor kids, anyone with special needs, anyone with probably a blended family, or someone who's got some spending issues, you're going to be on the trust side of the camp. When it comes to the wills, there are some pretty simple families who don't need all of the bells and whistles and maybe won't do an estate plan if they have to go down that bells and whistles route because it's just too much for them to think about. So in that situation, I'll recommend a will plan to them, underscoring that we're hoping the will never has to be used. We're hoping that it's just a safety net document if something slips through the cracks and needs to go through probate. And the way you would avoid probate is by making sure that on all their assets, they've named those beneficiaries. So if they're married, oftentimes that spouse will be named first, and then the kids would be named after that spouse. And you want to do that for, the investment accounts, life insurance, checking and savings accounts, vehicles, all those things that sometimes slip through the cracks. And then if they own a home, we'll do the deed work for them. We usually file a beneficiary deed that says if they still own that home after the second of that couple passes, the home will automatically transfer to the children. And so that's how the home bypasses probate. So when we're doing those designations, we want to make sure we get everything covered. And then all of those things are considered non-probate transfers. They don't need to happen with the court watching over them. And then in that situation, the will works fine because everything's been distributed basically without it.
Yeah, that's really good. Thank you for sharing it. And something we do at Falcon Wealth Advisors is each and every time we review with our clients, we review the beneficiaries that we have on file, because believe it or not, sometimes even that things can slip or things change. And maybe you have a daughter and she got married and we need to change the last name, or maybe you want to add a grandchild. So again, I think it's important also that people review those beneficiary designations, but that's it. That's very helpful. Thank you. So again, any bank accounts, investment accounts, vehicles, your house. Now I'm just curious, and this is a little bit morbid, but do you need so let's say somebody, has aging parents and they're in their 90s and they have a home that they lived in for 40 years. What about all the stuff in the house? Like, does that have to go through probate? Like, let's say they have an antique collection or guns or china. Like, how does all that stuff get figured out?
Yeah, that's a good question. So when you have a trust and we're looking to dump things into a trust that will avoid probate, we'll sign a document that says I've assigned magically all of that stuff to my trust, and then the trust's going to talk about how it gets distributed. When you've got that simplified path with the will, really it's a matter of writing down a form, making sure that we have it's called a personal property memorandum. That's where you're going to line item those things and to whom you want them to go. But you're never going to put everything on that list,
Right.
because who even knows what's in their house these days?
Right.
So really it can become kind of an honor system for those things that haven't been specifically designated to go to someone. But practically speaking, if your beneficiaries get along, and title on those assets, there's nothing preventing them from selling or donating or distributing them at your passing. Probate is really used for things that are stuck in your name and can't transfer to someone. So those personal property items aren't stuck in your name. Now they are stuck in conflict if something's really valuable and all the feelings of childhood get brought up and all of a sudden two siblings are warring about something that seems kind of silly.
Right.
Then you could file probate, but I rarely see something like that.
Got it. Yeah. Thank you for that. That makes a lot of sense. Now, what about, so again, so the stuff can kind of get divvied up as it may be. Now, if you have multiple beneficiaries on a house, is that wise? Like, let's say the siblings don't get along so well. I mean, what do you normally advise for? And I know this, by the way, quick disclosure, this is not legal advice, right? You want to sit down with Emily and actually have a one-on-one conversation with her. But I'm just
I don't
curious.
represent you yet.
Yeah, exactly. So I'm just curious though, like, let's say there's 4 children in the household and let's say they don't get along so well. I mean, would it, and again, they're trying to make it simple for the family. In that situation, does it makes sense just to maybe put one of your children down that you trust will make the right call, or should they put all 4? And if they put all 4, do all 4 have to agree on the house?
So it's depending on how you're going to transfer that ownership. Most often people will transfer it so that those named individuals are tenants in common. And that means that they each own a fractional share of the whole with no person having the right to any other's part. If you don't have a get along situation, that property can get kind of trapped because there may be disagreement about what to do with it. Some options could be, instead of naming all of the kids, you do an inventory of your assets, figure out kind of the estimated total value, and decide maybe these 2 kids that get along will get the house and the others will be offset through some other type of distribution. So maybe those kids on the house are not named on an investment account. That works in a way, but things aren't then completely equal because we don't know the values of everything when people pass, and there can be room there then for stickiness later if things aren't equal. So it may be in that situation where they don't get along, we look at doing a trust instead of that simplified path, so that in the trust, mom and dad can say what they want to have happen to that home. So instead of ownership transferring to the children, it transfers to the trust at their passing. And then the terms of the trust say what the trustee needs to do with that house. And the trustee is that person that mom and dad name to take over to carry out what that trust document says.
Got it. Good. And I want to go down that trustee road here just a moment, but I had another question. So what about debt? So let's say there's credit cards or loans. The mortgage is pretty obvious. Obviously you sell the house, pay off the mortgage, but what about what if somebody, has credit card debts? How does that all play out? Do they have to pay it, or how does that work out?
It's kind of hit and miss because there's no surefire answer. If you avoid having to open probate and you're just transferring all your assets to your children, the chance that a creditor is going to locate the children and claw back whatever you transferred is less than if everything went through probate, in which case creditors have to be placed on notice. So they will be able to raise their hand and say, I want a piece of this pie before it gets distributed to the beneficiaries. Same thing for a trust. A trust is largely privately administered. It's kind of the same situation as if you would transfer directly to a beneficiary insofar as creditors are concerned. Really, you're not supposed to not pay your debts.
Right.
That money is there to pay for that. But really, it's a matter of how persistent and what is the value of that credit and what is the value of that creditor to go after and try to get it. And it's easier to get it if your estate's in probate.
Got it. Makes sense. Interesting. Okay. That's a good little fun fact there. Now, often I have clients come in and it's very easy to get tripped up on when you're looking at their trust, beneficiary, grantor, and trustee. Can you kind of define how each one of those works a little bit?
Sure. So the usual trust that we'll create for someone is called a revocable living trust. And what that means is the grantors, usually an individual or a couple, come in and they create the trust document. They're the grantors. They're granting their property into that trust. They are also the trustees during their lifetimes, which means they have complete control over how that trust is administered. So the trustee is the person in charge. When it's the grantor who's serving as the trustee, it's a really just kind of seamless thing. The revocable living trust is entirely revocable, which means that while the grantors are living, they can amend those trust provisions and do all sorts of things. It only becomes irrevocable and locked after they pass. When that happens, the beneficiaries start to take shape, and their shares take shape. And it will happen at 2 points if we're dealing with a married couple. So when the first spouse passes, there's some shape that happens to that person's assets. And it may be that it transitions entirely to the surviving spouse, or it may be that their shares kind of held off to the side with some tighter controls in place, with the spouse still having full access to their own property. And then after the second spouse passes, then we have usually descendants, sometimes other family members or charities, whose shares are then established with whatever is left in the trust. So the grantors are kind of like, I don't want to call them beneficiary. They're kind of like beneficiaries while they're living because they can use all of their property. They could exhaust everything in that trust if they wanted to. And they serve as trustees, but they're the only grantors to that trust.
Oh, got it. So nobody else can grant to a trust that they establish. Is that right?
They probably could, but they wouldn't be the ones that establish the trust. So the trust will also specify who's going to be trustee after the grantors. During periods of incapacity, we'll name someone to serve, someone or something. And then after they pass, we name someone or something. And I say something because sometimes there are trust companies who will be named successor trustee. And that can be a good situation for families who maybe don't want to name a family member. Maybe there is stickiness to your example of the inheritance of the house. If you already know that people aren't getting along, it doesn't make sense to put someone in charge of everyone else. You're just going to, end run all those relationships even further. So a trustee can be a good option. There are trust companies that won't invest assets. So they just kind of take a hands-off approach and instead they just manage all the other parts of the trust. So, if your clients love what you all have been doing with their investments, there are ways that we can name a trust company and just have all that remain the same so that they have some peace of mind that there's that traction and it continues.
Yeah, thank you, Emily. That makes a lot of sense. Now, so there's a lot of responsibility though, right? So if you do name, your child as the trustee, they have to file a tax return, carry out all your instructions. So it can be a little bit heavy of a weight. So of your clients, how many people, and maybe a lot of people name humans, like how many people name humans versus hiring or putting on a trust company? Do you know that ratio by chance? Or
I think it's probably about half and half. I recommend it to everybody because I think people get lost in thinking, this is the last time I can make sure that this child knows that they're gold star.
Good point.
That they're amazing and totally responsible. But it's a burden. That is not a gift. That is not an honor that you're bestowing on somebody. So I encourage people not to think of it that way. You know, the trust documents can be long because they're comprehensive. They don't know what life looks like when they take shape. And because of that, they're, you know, dozens of pages long.
Right.
And give that to a person who's not experienced, who's also mourning your passing. Let's not forget, like, what happens. And it's a lot to take on. So it's meant to be simple because it keeps it out of court, but it is a big job for that one person that you've kind of stuck in that main role.
Yeah, that's good. And, you know, so for people listening or watching this show, how often should they review their will or their trust? Because I think a lot of people also, when they come in, they're like, oh yeah, I've already got that trust, I'm done.
Yeah.
But how often do you typically review with your clients, or what do you recommend?
Yeah, I mean, it's awesome when it gets off the to-do list, and you know, I love it when people cross that finish line, but we want to circle back to the finish line probably every 5 years or so, unless there's another significant life change. So the trust themselves, if you do a trust, you know, afterborn children, you know, kids that you have after you created it initially are already included in the definitions, most likely. So that's not, it's a big life change, but it's not one that necessarily warrants having to change your trust. But as kids age, you may want to put them in different positions within your estate plan that were used to be held by your parents, who are now maybe too old to serve in those roles. If you get divorced, please go redo your estate.
Right.
And update those beneficiary forms like you talked about. Talk about slipping through the cracks. If you've got that former spouse still named on something, they'll raise their hand for it. You can probably undo it, but I'll probably try to get it. So I say 5 years or so, circle back. Sometimes, you know, laws change, like some of the retirement laws changed here in 2020. And so there's reasons to kind of talk through things again, just to make sure that your original purpose and plan is still set on a path that's going to be achievable.
Yeah, good. And that kind of leads into our next section here is, do you have any like good do's and don'ts for people when they're looking at their estate plan, whether that's a will or a trust or beneficiaries? Like, do you have any kind of quick tips that they could just kind of things to think about?
Yeah, so I think one big thing is don't presume that the default in the absence of doing something is going to be what you wanted to have happen. So if you don't create an estate plan, Missouri and Kansas have one that they're going to assume you wanted. And by that, I mean, if you've got assets stuck in your name when you pass, probate will be opened, but no will be filed to say what you wanted to have happen. And rules of intestacy take shape. And that's just a one size fits all kind of paradigm that each state has said, this makes the most sense to be universally applied to everyone. So if you're in a relationship, maybe you're not married to that person, or I don't know. I mean, it could be any number of things. You don't have children, but you know your sister is the one you want to provide for and not some others. Unless you write that down, it's not going to default to what people say you wanted. It's going to default to what the law says. Same thing for powers of attorney. So those are really important documents because they allow someone to act on your behalf if you're incapacitated and can't do so yourself. I often see people bring in parents who maybe are too far down the road and can't make that decision. And then you're kind of stuck and you got to go through a longer procedure to get someone in place for you to act. The other thing I would say is don't let imperfection delay you doing an estate plan. So, you know, we draft the best estate plan that we can based on what we know now. If things change in the future, we tweak them. But don't sit on your hands because you don't 100% know exactly how you want things to go. Do your best now. You can't foresee the future. And depending on what happens, you just rework things then.
Yeah, that's a good point because I think a lot of people are a little intimidated by the process. Yeah. And, you know, some of your questions, I haven't seen your questionnaire, but some of them are pretty thorough.
Yes.
So if they don't know all those answers, you're right. They just don't do anything. So that's really good. Get something filed. You could always update it and edit it, but that way at least you have something going.
Exactly. And that worksheet, ours is comprehensive too. And I try to tell people, just throw in question marks if you don't know, because I can use anything you give to me to put together drafts. We just highlight those areas where we need to make decisions later. And then once people can look at the drafts with us, all this kind of amorphous talk about trusts and wills and powers of attorney takes shape. And then it becomes easier to make some of those choices because we can talk through actually how they work in the documents.
Right, right. That's good. And another common one that we see is that people don't fund the trust.
Yes.
So they do, and maybe you can talk to that. They do all this work with their attorney and they create a trust and they think it's magically over. So talk about the step after you actually create a trust. What needs to happen?
I see people just yesterday came in with an estate plan 15 years old, and we talked through how that trust gets funded, and I could tell by the look on their faces that those steps hadn't been done yet. So we take care of funding the trust with the real estate. So that beneficiary deed that we file is the avenue that gets that house to the trust. But the vehicles to get the other assets to the trust are through those beneficiary designations or by changing ownership of an asset from yourself to your trust. So for folks that work with you, it's easy because they call and they say, I need to update my beneficiary designations. They'll have a name for their trust that will oftentimes be either the first or second beneficiary on those assets, depending on what it is. And then that's the path, basically the road that's been paved for that asset to get to the trust. But then it's really on people's own accord to DMV, get the trust listed as TOD, or the next time they buy a car, instead of using their name, they could use the trust instead. Same thing for bank accounts. So part of that worksheet process is helping people create an inventory that they can backtrack through later and check off as they update the trust as either owner or beneficiary of those assets.
Got it.
You did nothing and everything was still stuck in your name. You'd have a backup will that would be filed for probate. And in the case of a trust, it says, put it all into my trust. So that's the voice that you put in that type of will. So I always kind of think of it as like a kind of long highway detour. You're going to get to the same destination. Stuff will get in your trust, but you created that document so that you could avoid dragging your family through probate.
Right.
It's right there. You got to update your beneficiary forms anyway. So just get that trust listed, and then things will kind of dump into that trust bucket and they'll be there kind of set and ready for when it needs to be.
Yeah, thank you. That's good. And I've heard before, and I don't know, I want to hear what your opinion is on this, but I've heard that sometimes attorneys will advise clients to not put their checking account in their trust because I think it's maybe a flag that people will assume you have a ton of money or something. So, so talk about that a little bit.
Yeah, so I've heard that too. And I think I think banks don't have to put that on your checks. So it doesn't have to be printed that way in order for it to be in your trust. But that's kind of the example I get is, do you want your vehicle in particular? I think this is maybe a bigger one, to be titled in your name or in the trust name. If you get rear-ended and someone finds out a trust, are they going to be more inclined to sue you? That's where my litigation hat goes.
Right.
So, it's kind of all about how you want to represent yourself to the world. Now, some people will also do kind of ambiguous names for their trust. So instead of, Joe and Jane Smith Trust, it'll be the Sunflower Trust, or a little more ambiguous like that. I think it's kind of hard to cover up who the trustees are, and if it ends up being you anyway, I'm not sure that ambiguous name really gets you there. But there are some options for trying to kind of smooth over some of those edges if you want to own more things in your trust now, as opposed to having them transfer there when you pass.
Got it. Good. Yeah, that's good. And I guess ultimately you could keep the car in your name and just put the trust as a beneficiary, and that probably would be pretty close. Okay. Good. Well, perfect. Well, I know we're kind of winding down on time here a little bit. Is there anything else that I missed? Anything that's really need to know? This has been very informational, so thank you. Is there anything else that we missed?
Oh man, I don't think so. I think sometimes people don't get off the ground with their estate plan because they don't have all the decisions made yet. sometimes people don't get off the ground because they're a little bit nervous about having some conversations that they might have to have within their family to talk things through. And I think getting in front of an attorney and a neutral who can kind of ask some of those tough questions that may not feel good to ask while you're unloading the dishwasher at night with your about what to do with, their kids from a prior marriage, getting kind of in a conference room with someone else can help smooth over and jump into some of those conversations. So I would encourage folks to reach out to an estate planning lawyer. No estate is too small. It's really just about your family and how you want things to be distributed. That is the most important piece. And all families have important people, so all families need an estate plan.
Yeah, makes good sense. Now, what about a couple that doesn't have kids yet? I mean, and they're waiting to have kids, but I didn't know that. You could write in future kids in a trust, so there's really not a reason to wait.
Right. So you can, I've written, so first, let's say you have one child. I have a couple clients with the second one on the way. No name yet, no birth date, but the definition of children encompasses future children. I've worked with couples who don't have children, and instead we expect that we're going to have children. And if we do, this is how this is going to take shape. Or if you don't plan to have children, all the more important to name who you would like to put in those places, because most likely the default of what Missouri or Kansas says you want is probably not what you want. You probably have a different iteration in mind. So don't let kids be the decider of whether you need an estate plan. You need an estate plan to always plan for what happens after you, or if you're in a relationship, what happens after that person.
Got it. Yeah, that's good advice. Thank you for that.
Yeah.
And now just kind of to wrap up our show, a fun topic. Is there anything that you're interested in as far as TV shows, books, vacations? Is there anything on Emily's plate here that's outside of law?
Oh, well, yes, lots outside of law. I have 2 kids, so when I'm not here, I'm mom. 12-year-old and I like to binge watch different TV series. We've done Brooklyn Nine-Nine, Superstore, lots of, Big Bang Theory. That was a lot of episodes, but every single one of them.
Nice.
So we kind of watch those things. I listen to my brother and sister-in-law's podcast called Road Tripping in America. They sold all their stuff and are traveling around the country and have been doing so for the last year. So they live a completely different life than I do, but it's fun to listen to and see where they're going and what they're doing. What adventure.
Oh yeah, that's awesome. Yeah, good for them. And Road Tripping America, good for them. And so they, how often do they put out a podcast? Is it weekly, monthly, or? I
think my sister-in-law largely does it. We never knew this, but once you hear a voice on a podcast, you're like, you were made for this, Lisa. So I think at least once a month, but maybe a little bit more often than that.
Awesome. Yeah, good for them. That's very cool. Well, thank you again for sharing that. Thank you all for tuning in. And again, if you have any questions for Emily or want me to connect you, I'm certainly just send me a note at jake@falconwealthadvisors.com. Happy to connect you with Emily and her company. And that's good. It's good advice, Emily. Don't wait. If you're thinking you got to have kids or something else, let's get that estate plan in place so that, God forbid, you don't want something to happen to you and the state decide where all of your hard-earned money and assets go, because you can actually direct that by getting that set up. So thank you again.
Thank you.
Yeah, thank you. And thank you all for tuning in, and we hope you have a great week.
Thank you for listening to Upticks. Click the subscribe button to be notified when new episodes become available. Also, be sure to visit our website, falconwealthadvisors.com, and click the Contact Us button if you'd like to meet with Jake and his team.